In this video, we're talking about two different crimes that are present in Arizona called minor in consumption and minor in possession. So this happens when people who are under the age of 21 who are not allowed to drink either have possession of alcohol or they have already consumed alcohol. They're both contained within the same statute. It's under Title IV, 244.9, and this is the text that really governs the law here. And let's dive into it. We can see what it says. You'll see that it encompasses both possession and consumption. So let's take a look. It is unlawful for a person under the legal drinking age to buy, receive, have in a person's possession, or to consume spirituous liquor. So you can see it kind of crams a lot in there, but essentially this means that if a person who is under the age of 21 is in possession of alcohol, whether they bought it, whether somebody gave it to them, whether they found it on the street and it's in their possession, that's illegal. It's also illegal for somebody who's under the age of 21 to consume alcohol. So if the police show up to a house party and there's people who are under the age of 21, they believe them to be impaired or under the influence of alcohol, they can cite them with that. If they're just in possession of it, if they're driving, if they're stopped for a traffic ticket, an officer sees a bottle of alcohol, they can cite that individual for that. It's possession of alcohol. In Arizona, this is a serious offense. It may seem pretty minor, but it's actually a Class 1 misdemeanor. So in other videos I've spoken about this, but Arizona has different classes of misdemeanor offenses. So these are not felonies. Felonies are the big ones where you lose your right to vote, you lose your right to own a firearm, you could potentially go to prison. These are misdemeanors. And in Arizona, we have three classes of misdemeanor. Class 1 is the most serious. That's what this is. Same classification as a DUI, as domestic violence offenses, as certain types of serious assaults. And so it's quite serious. So somebody who's a very young individual, 18, 19, 20, can be charged with a Class 1 misdemeanor for going out to a party, having some alcohol or being around alcohol, being in possession of alcohol. So certainly it's something that you want to be concerned about. You want to make sure that this is being addressed appropriately, because as a young person, you've got your whole life ahead of you. You want to make sure that you do not have convictions that follow you around forever. And so the maximum penalties that are available under the law for a Class 1 misdemeanor, up to 6 months in jail, up to $2,500 in fines. They can tack on surcharges, and up to 5 years of probation. I didn't put that on here, but it's 5 years of probation. So you can see the penalties are pretty severe. Now, I don't see people, my office has never seen anybody get that type of penalty for something like this, but it still is a Class 1 misdemeanor, and it can still go on your permanent criminal history, and so you want to be sure that this is dealt with appropriately. One additional penalty that's available under the law, this is up to the judge, but a judge, if the person who is charged and convicted of this is under the age of 18, the judge can suspend that person's license for up to 180 days. So even if they're not driving, they've got nothing to do with a car, they were just having some alcohol, under the age of 21, a judge can suspend their driving privileges up to 180 days. So it can keep somebody who's 16, 17 off the road for quite a while. Certainly, we want to make sure that that doesn't happen. We want to make sure that if you're charged with a minor in possession or minor in consumption, that you do not get convicted of it. So what are the most common outcomes? Well, first of all, most of the individuals that we see who come through our office, we are able to get them what's called diversion. Diversion means you take some classes, you take an alcohol class, an adult responsibility class, you do something, and in exchange for doing that thing, we turn around and ask the government to dismiss the charges. As long as you don't get in trouble again, as long as you successfully complete whatever program we're able to work out, they dismiss the case against you. It's a good deal. You do something, the government does something, case gets dropped, everybody's happy about it. In some situations, that doesn't happen, though. Sometimes somebody will have a prior for something, a prior criminal speeding, or a prior reckless driving, or maybe a prior minor in consumption, and they get another one. So then the government doesn't want to give you another diversion. They say, we've already given you one chance. You shouldn't be getting another opportunity for a dismissal. Well, in that case, sometimes these things have to go forward towards a trial. At a trial, there are many defenses in these types of situations. They don't often go to trial for these reasons because most of the time, the police don't do a good job in capturing evidence that's required to prosecute somebody. As I said, this is a Class 1 misdemeanor. It doesn't matter if it's a Class 3 or a Class 2. They all follow the same rules of criminal procedure. So this would follow the same rules as if you were charged with a DUI. And truthfully, the same set of rules as if you were charged with a homicide. They have to produce the evidence to prove that you were in consumption of alcohol. You had alcohol in your body. In most of these situations, they're not taking blood. They're not going and getting a warrant and withdrawing blood and impounding these things. They're just doing a portable breath test. There's a lot of arguments as to whether or not those things could be admissible, whether or not they're accurate, whether they're properly calibrated and maintained, whether they account for mouth alcohol, whether they did a proper deprivation period. There's a lot of different arguments that can be made to show that you weren't actually you weren't consuming alcohol, or if you were, that the government can't meet that burden of proof. They have to prove it beyond a reasonable doubt. It's a very high standard. So just because you've been charged with this or have priors of these things doesn't mean that you cannot beat this at a trial. There's a lot of ways we can keep all of that evidence from coming into court, or if it does come into court, really undermine the credibility there. So it is important that this gets dealt with. You certainly do not want to have a conviction for minor in consumption, minor in possession. It's something that we deal with regularly. We have a team here who does only criminal defense law, so we deal with these issues all over the place in all corners of Arizona. A lot of it does depend on the different jurisdiction you're in. Sometimes jurisdictions are more favorable, sometimes they're less favorable. So you want to be sure you speak with a team that's experienced, that can make sure you have a plan in place. If you have been charged with minor in possession, minor in consumption, give our office a call. We offer free case evaluations. We'd be happy to have you come in, sit down, talk about the specific facts of your case, make sure you have a plan forward to avoid being convicted. Give us a call. Look forward to speaking with you soon. Thanks for watching.